Now let us also discuss the trend of takeovers and acquisitions in India. The trend of takeovers and acquisitions in India, it witnessed significant regulatory changes in 2011 as we just discussed. And when this new takeover regulation 2011 came into force, it brought with it several unique features which now govern the takeover transactions, the acquisition transactions in our country, and especially it applies to public listed companies. The basic principles which applies to an acquisition and a takeover is that in case of a takeover, compliance of both the takeover code as well as the act is necessary. While in case of only acquisition, especially in case of acquisition of unlisted companies, compliance only of the act is required. Similarly, there are other variants which can be added to it. So when an acquisition becomes a takeover, the provision of SEBI Takeover Code 2011 becomes applicable, as we all know. Similarly, if an acquisition results in a combination, then along with the Takeover Code 2011, the provisions of the Competition Act 2002, which were further amended in 2007, would also apply, and the approval of Competition Commission of India is required in such a case. And if the acquisition results in either inflow or outflow of funds to and from India, then the provisions of FEMA 1999, that is the Foreign Exchange Management Act 1999, would also become applicable along with the Takeover Code 2011. Now, after having discussed the basic, the fundamental concept, the meaning of takeover, acquisition and the differences between them, now let us discuss the various legal provisions. SEBI is a body, is an authority which has given to us a very comprehensive set of regulation which governs all forms of takeover activities in India. And therefore, all kinds of takeover, whether friendly, whether hostile, have to necessarily go through the procedure which is given under the SEBI Takeover Code. This code involves the acquisition of shares in a substantial percentage, which leads to acquisition of control and finally takeover of a target company. It also applies to acquisition by a company. This acquisition can be acquisition of shares, acquisition of voting power and acquisition of control. Acquisition of shares can be either direct acquisition or indirect acquisition. Now, what is a direct acquisition? A direct acquisition is when control of a public listed company is by way of acquisition of shares of the target company directly. Whereas an indirect acquisition, it is done by acquiring shares of a holding company or a parent company of the target company. Therefore, both these forms of acquisition, they are given under SEBI Takeover Code and are governed by the same regulation. SEBI Takeover Code also gives to us a process which is known as an open offer process. The Takeover Code mandates an open offer process for both direct as well as indirect acquisition of shares, voting rights or control if such acquisition triggers the threshold prescribed under the Takeover Code. Now, what is this threshold? We need to understand this. This threshold is given under Regulation 3 of the Takeover Code 2011. Regulation 3 gives to us the concept of substantial acquisition of shares, voting rights and control. Thus, every acquisition of shares is not a takeover, only substantial acquisition of shares is a takeover, and if it is so, whenever it is a case of substantial acquisition of shares, then the acquirer company has to comply with the provision, comply with the norms given under Regulation 3 of the Takeover Code, which requires the acquirer company to follow an open offer process. Regulation 3 of the code requires a public announcement to be made for every acquisition of shares, every acquisition of voting rights and every acquisition of control, which is more than 25% but less than the maximum permissible non-public shareholding in a financial year, which is generally 75%. Thus, there is no requirement of going through an open offer process by making a public announcement if the acquirer acquires shares up to 24.99% within a financial year. But as soon as he triggers this threshold of 25%, he has to make a public announcement and he has to go through this open offer process. This percentage which is given under the Takeover Code 2011 was quite low under the previous takeover regulation. It was only 15%, but now they have increased it to 25%, which comes in a form of relaxation both to the acquirer companies as well as to the shareholders. The open offer process requirement should be fulfilled only when there is a substantial acquisition of shares or voting rights or control. Having done substantial acquisition of shares or voting rights or control by making a public announcement, if an acquirer has to acquire additional shares which entitles him to exercise more than 5% of voting rights in a financial year, he is again required to make public announcement of an open offer. From this, we get the concept of creeping acquisition. The concept of creeping acquisition allows an acquirer to acquire additional shares every year, I mean every financial year, up to 5%, for which he is not required to follow the open offer process. So, if he acquires 5%, up to 5% in one financial year, for that he is not required to make public announcement, he is not required to follow any open offer process. So, therefore, this is a slow acquisition, this is a creeping acquisition, but this can be done only once he has acquired substantial acquisition of shares. He has done substantial acquisition of shares or control or voting power. Now, under the Takeover Code of 1997, as we just discussed, an acquirer was mandated to make an open offer if he alone or through persons acting in concert with him, they were acquiring 15% or more of voting right in the target company. This threshold of 15% has been increased to 25% under the Takeover Code 2011. Now, what is meant by acquisition of control? Acquisition of control substantially differs from acquisition of shares and voting power. Takeover Code mandates making of a public announcement of an open offer for acquisition of control, which is done either directly or indirectly over a target company. This is irrespective of acquisition or holding of shares or voting rights in a target company. The Code of 2011 under Regulation 5 gives to us the concept of indirect acquisition of shares or control. In case of an indirect acquisition of shares or control, the acquisition of shares, voting rights or control over any other company which would enable the acquirer of shares, voting rights or control to exercise such percentage of voting rights which would otherwise have triggered an open offer process and which would enable him to enable the acquirer to exercise control over of a company, then this becomes a kind of indirect acquisition and not a direct acquisition. Thereby it is meant and thereby it is concluded that even in case of an indirect acquisition, he has to follow the open offer process. The concept of deemed direct acquisition is a little different from indirect acquisition. Few or certain indirect acquisitions, they are regarded as deemed direct acquisition or deemed to be direct acquisition if such indirect acquisition satisfies few conditions. These conditions are that if the proportionate net asset value of the target company as a percentage of the consolidated net asset value of the entity or business being acquired exceeds 80%, or the proportionate sales turnover of target company as a percentage of the consolidated sales turnover of the entity or business being acquired exceeds 80%, or the proportionate market capitalization of the target company as a percentage of the enterprise value for the entity or business being acquired exceeds 80%. The deemed direct acquisition in all these three cases has to follow the same mandatory open offer process related requirement which are being followed in case of a direct acquisition of shares, or direct acquisition of voting rights, or direct acquisition of control. Regulation 6 of the Takeover Code 2011 makes us understand the concept of voluntary offer. It provides an option to make a voluntary offer under the Takeover Code of 2011 to those shareholders who already hold at least 25% or more but less than 75% of the shares or voting rights of that company. The reason is they wish to further consolidate their existing shareholding rights in the company. Then this option to exercise voluntary offer is given to such shareholders. Voluntary offer enables such shareholders to acquire further shares representing at least 10% of the total shareholding of the company. But making of such a voluntary offer is not without restriction. So therefore, there are certain restrictions to make a voluntary offer. For example, one is it puts a moratorium period. A person who either individually or together with the persons acting in concert has acquired shares or voting rights or control in the preceding 52 weeks otherwise than pursuant to an open offer is not entitled to make a voluntary offer. Similarly, during the offer period of such voluntary offer, acquisition of shares in the target company are prohibited. Another restriction is that the acquirer who makes a voluntary offer is not entitled to acquire any shares of the target company for a period of further 6 months after the completion of that voluntary offer, except by way of another voluntary offer or a competing offer. And another restriction is that the shares proposed to be acquired under the voluntary offer should not be in such number so as to reduce the public shareholding of the target company below the minimum permissible limit, assuming that the offer is accepted in full. Therefore, these restrictions have to be followed in case of a voluntary offer, and this facilitative provision or option is given to those shareholders who want to further consolidate their shareholding only after they have already made a substantial acquisition of shares or voting rights or control in the target company.